Hi everybody, happy Tuesday. It's August 5th. We are a few weeks away from school going back. Football for my older son started a couple weeks ago. He's playing tackle, and my younger son's still playing flag. He starts tonight actually. I'm head coach of that team and assistant coach of the tackle team. So my nights are busy, but I'm very fortunate to be able to coach them. Today I want to talk about a little question a lot of people ask me, comes up quite a bit, about how to avoid probate with your house. With bank accounts, it's very easy. You just name beneficiaries the way that you want them. For a house, it's a little bit more complicated. A lot of people don't want to pay for a trust or don't want a trust for various reasons. So the question is there a way to do it without a trust, and when do I need a trust versus not having a trust? So from my perspective, the answer is pretty clear. If you really want to avoid probate with your house, if you're leaving your house to one person, if you have one kid, or one significant other, or anybody you want to leave to one person, then I would say a transfer on death affidavit is a no-brainer. That's something that can be recorded with the Lake County, well, whatever county, but the recorder, the owner of the house retains ownership, and it's basically at your death, the person that you designated the house to automatically gets the house. Now there's a form you have to file along with a copy of the death certificate, but it's not like it's got to go through probate. Just goes to them automatically at your death. You just present the notarized form and the copy of the death certificate, and that's it. The reason why one person is a no-brainer is the more people we're going to leave it to. Like, I have 4 kids, so if I'm going to leave my house and transfer on death to my 4 kids, this is a bad example because they're young and can't own property, but if they were all adults and they were all married, let's say, and I transfer on death my house to them, all 4 of them have got to be in agreement on a sale. And if they're all married, all 4 of their spouses have to be in agreement on the sale because they have what's called dower rights. So logistically, it's very hard to coordinate 8 people. What I've seen happen quite a bit is, maybe one of the 4 kids moves in with the parent to take care of them, and now we've got 4 equal owners, but one of them actually lives there and they're in no rush to sell because they've been living there for a few years. Or maybe somebody's spouse is going through a divorce and they're estranged and they're not going to cooperate on signing anything, and so it turns into a gigantic mess. So it would have been easier just to let it go through probate. So if you really want to avoid probate and you're leaving it to more than one person, then I would recommend a revocable trust. We put the house into the trust, and it's subject to the terms, whatever you want to put in the trust in terms of how it's going to be disposed at your death. Lake County, I tell everybody, Lake County Probate Court and all the counties around here are the same. They have set amounts attorneys are allowed to charge. So it's 4% of the first $100,000, and then 3% of everything after that, up to a certain amount. And I don't have it right in front of me, but the point is, if your estate alone is a $300,000 house, that's $10,000 in attorney fees right there if it's got to go through probate, all of which could be avoided with either a transfer on death affidavit or a revocable trust. That's not even talking about avoiding creditors and getting it done quicker and all that. So there are multiple advantages of having your house avoid probate. It's just a question of your specific situation, how to get it done. All right, thanks everybody. Have a great week.